And welcome back. It's time for Opinion Court. Thank you for staying with us. Get in touch with us. 22422 is our SMS line. You can find us online at Citizen TV Kenya, at Citizen TV News. I am at Ann Kiguta, that's Ann with an E. Please use the hashtag Opinion Court so that we can track your conversation and include it in our discussion. I will reintroduce my guests to you and our topic of discussion. To my right is Dagoretti MP Dennis Waweru. To my left and next to me is Nabil Orina, who's an international law expert and of course an advocate of the High Court as well. And next to him is of course Edward Kisiangani, our resident political analyst. We are picking up our conversation today from the point where the Attorney General has asked the ICC prosecutor to forward the files of 3 Kenyans wanted at the ICC over witness interference so that they can be prosecuted here in Kenya at what should hopefully be soon operational as the International Crimes Division of the High Court. And my first question to you all, is this finally evidence that Kenya is committed to justice for both victims and suspects? Nabil.
I take the AG's statement to mean that Kenya at least is making steps towards ensuring that there is some prosecution of those who would have been considered mid-level or lower-level perpetrators, not just those who've been accused of witness interference, but it means that Kenya is moving towards operationalizing the proposed International Crimes Division to ensure that at least the issue of post-election violence of 2008 and those who are suspected to have been responsible can be prosecuted locally. And it's a good step to ask the prosecution or the prosecutor of the International Criminal Court to share evidence or material they might have that is useful to go ahead with such prosecutions.
All right, Dennis?
I think we are not where we are. We were 8 years ago. When we referred our cases to ICC, and I think it's a step forward. It's a demonstration how much we have reformed our judiciary, how much we have gained confidence in our judiciary, and I feel this is the right step forward. As you're aware, ICC is actually a complementary court to our jurisdiction. It's not a first call court, and so it's very welcome that we have shown that we can be able to prosecute or handle cases within our jurisdiction.
All right. Prof, Kenya's commitment to justice, do you think?
It is a public relations exercise. I think what the Attorney General is doing is actually useless in a sense, because the people that are supposed to be tried in Kenya are not ordinary people. The trial of Gisheru, Bet and Barasa has a link with the collapsing case of the president and even the deputy. So if you renew the prosecution against them, it's like telling the Kenya government, where Uhuru Kenyatta is the president and Ruto the president, that you tried to interfere with the evidence, and then that evidence was supposed to touch on me, and as a result of that the case collapsed. Now I'm accusing you of the same, and I want to put you in. The government can be trusted on this? No, it can't, because it touches on the president, and it can renew a few things which touch on the president and deputy president and the other guys. So on that it is not possible. It's a public relations exercise. And then the second quick thing that I want to say is that there is no local jurisdiction that we can talk about. Even the Attorney General himself has talked about to be formed. It hasn't been formed. This government and even the past government has stayed for over 6 years, 7 years, 8 years without forming a local tribunal. It is again a public relations exercise, so it will not work. And then finally, with regard to the Kenya's withdrawal from the ICC, the procedure is, even if the president announced, he knows the law. Under Article 2 of the Constitution, there is a procedure we shall use to amend the Constitution so that that aspect of ICC which is domesticated within Article 2, that all the rules of international law apply and become the laws of Kenya, is changed through some process. In fact, in my opinion, because that section touches on the supremacy of the Constitution, we shall have to go for a referendum. So therefore, even if the President wishes that we withdraw from the ICC tomorrow, there are some legal things that have to be done on the ground, it's not going to be possible.
Well, there are two elements that you've brought in, which is the political and the legal, you know, whether it is practically, legally possible to be able to do that first. So let's start with that, and let me talk to you, Nabil, about that. What needs to happen in order to operationalize this ICD division of the High Court specifically? How much time would it take, and how possible is it to see prosecutions on these three characters, should the ICC comply, perhaps before the next general election?
There is no requirement that there must be formed a special kind of court for such prosecutions, because the only steps the judiciary needs to take are just administrative steps to form this division within the existing judiciary and to assign judges to take over this process. So it's not a process that would require months or years. If all the parties, all the stakeholders are willing to do this or want to do this tomorrow, it can be formed, judges will be assigned to that division, and the prosecutions can start. But it's all the, it's not just...
No legislation needs to be in place for it?
There's no legislation needed. We have the International Crimes Act. The International Crimes Act talks of courts of competent jurisdiction to prosecute some of these crimes. It gives jurisdiction to the High Court of Kenya to prosecute crimes against humanity, war crimes. So this is not something to be formed for purposes of where we come from. It's something to be formed, you know, for the future and for now. So that even if something arose, war crimes arose in Kenya, crimes against humanity, genocide, then this court, this division within the High Court can be able to adjudicate over this, and still this division can be able to oversee such prosecutions within the magistracy. That's my view.
So it's just a matter of assigning judges. But there is the political question which Prof has brought out, which is the goodwill to actually see prosecution in these cases. These particular three individuals being accused of, as Prof has rightly put it, you know, what quote-unquote let the president and the deputy president off the hook in the opinion of the ICC? Can we still trust government to actually want to get to the bottom of the matter?
I think it's important for us as Kenyans to start having confidence in institutions that we do create. And of course, and I want to correct Professor, we must agree that we have vacated from a position that we were 7 years ago. We have a relatively independent judiciary, and a very good demonstration of how independent our judiciary is by, for example, and we had a discussion about the security laws, which we passed as the legislature, and eventually part of that registration was suspended by our judiciary. And so you cannot say that is cosmetic, is a PR gimmick. I think we have seen a lot of improvement in the way our judiciary has been operating, independent of executive. Number two, I do not also agree that we need to amend the law. I think within the current provisions of the law, we can be able to come up with a special court. We have several special units in the judiciary under which special crimes can be prosecuted. And I also want to emphasize that actually ICC, or referring the cases to ICC, should actually be not a court of first call. It's not something that is not somewhere you just go the other day, the next day, and start looking for justice in ICC. You should have exhausted our judicial mechanism, local judicial mechanism, before we refer cases to ICC. And I think it's important for us to also have some little bit of confidence in the institution until we have reason to believe that they cannot be able to deliver justice within our laws.
You are a learned man, yes. So you know what we are talking about. This case is a very special matter. Yeah. It's not that we are questioning the independence of the judiciary. Yeah. We are looking at a special case. For example, Walter Barasa was accused of interfering with the witnesses who were supposed to testify against the deputy president. Specifically, that case was mentioned by the prosecutor. Now, suppose you come to Nairobi, you have a special division of the international crimes, and then you say Now, Baraza come, you are facing this charge. You interfere with witness, and maybe somebody offers to say that actually I'm the one who was told by Baraza not to go and testify. In political sense, do you think that case, if you were the head of state, you look at me in the face and say you can allow that case to continue? I want you to be honest, because I suspect you are a Christian. Yeah. Yes. So face me and tell the public that yes, I would still allow the case to go on.
Yeah. I think, and I want to tell you.
And if you are the judge,
I believe I also want to look at it in terms of when we say that, for example, we are referring a case, we can't start showing some level of not having confidence in our system. I believe we should give our jurisdiction some level of confidence. Let's see what happens, and if you don't get justice, then we can be able to refer those instead of trying to say that we cannot.
My suggestion is this.
Yes.
The way to come out of this quagmire is to say, let Kenya, even led by Professor Githu Muigai, let us negotiate an exit from this case. In fact, Walter Baraza and Gishero are not even victims of the post-election violence. So the International Crimes Division in the High Court must deal with the victims. The victims are there. It's not about Walter Baraza. He is not a victim. So we are trying to deal with people who are actually tertiary in this case. So we want to negotiate and say
that wouldn't be the right place to try.
We have not even started dealing with the post-election violence. So what we do is this International Crimes Act should now go back and find out who banned who in Eldoret, and deal with these specific guys that committed crimes and which the local police can do and still prosecute.
Well, the government would dispute that, wouldn't they? There are several cases to deal with post-election violence or actually dispensed within the courts, and that the major problem in most of them was evidence collection, correct?
And if that is the case, if that is the case, Anne, then it is in our interest now to have this. The ICC is being naive. Actually, this ICC, it needs somebody to sanitize it, because it is clinging on webs, and the matter is already sinking. Why is it pursuing this Walter Baraza case? It is related to the major case which has collapsed. So I wanted these two people, the ICC and the Kenya government, to lock themselves in a room and say, we're chasing air. So let this thing collapse, and then there's no need of prosecuting them.
And we also need to understand that even the evidence correction was poorly done.
Yes.
And so the basis of these cases was on poor correction of evidence.
So this case is a waste of time.
Let's hear from Nabil.
My view would be that indeed there is need to at least clean up the process that we've seen, and under the International Crimes Act, Kenya has jurisdiction to try even those who gave false testimonies before the ICC, before the court. There is still a lot that is being swept under the carpet if we want to say that, you know what, let's not look into this. And for purposes of Kenya, and I think for good faith, if the prosecutor also is interested in good faith, to ensure that national jurisdictions are strengthened, and as Muheshimiwa said, they have primacy. Kenya has primacy over all these crimes. Let's look at who are these persons who gave false testimonies before the court. Can we have this, evidence from the prosecutor shared with Kenya, because even the International Crimes Act as well as the Rome Statute emphasize the role of national courts in especially prosecuting crimes of that seek to interfere with justice. So I think this is a good step that Kenya can pull up, can show that it actually can take up such cases, because out of all the criticism that Kenya could not take up these cases, we've seen tremendous reforms within the judiciary, and I think it's the best chance to start off.
You know, Wakili, we have not even reached the point where we say, people gave false evidence. From the point of view of ICC, the evidence was credible, but somebody interfered with it. From the point of view of Kenya, just wait. From the point of view of Kenya, this evidence was even false. The ICC didn't do a good job. So instead of us confronting each other on this matter, the case has collapsed. So what we should do now is, for example, if you bring Baraza and you start the case afresh, the healing process in a political sense, which we want to embark on, will be interfered with. So really we shouldn't go back to looking at three gentlemen who are supposed to have interfered with witnesses, and the case has collapsed.
But Prof, there's also the argument, just hold on a second, there's also the argument that, you know, the healing process is as much about forgiveness as it is about justice. So to argue that, you know, one can only be healed in the absence of justice, or the ICC should not pursue every possible legal means to find truth and or justice, then really is a fallacious argument, isn't it?
I think we have, as a country, I think we have moved on. I don't think we should be dwelling so much on what we should be putting all our efforts in is about resettlement and compensation of the victims, instead of looking at, in fact, if going by your argument,
yes,
we should now be even looking for those people who procured witnesses, false witnesses. In fact, that is where we should be looking at, not looking at what
Nabil, I'm going to have to help you to come into the conversation here. What do you think? What are your thoughts?
My thoughts in regard to this, because I think Prof's arguments are a bit contradictory here. Do we abandon looking at all these, you know, accusations of you know, interfering with witnesses or procuring false testimonies? The court itself was quite clear that other than the fact that there could have been lots of interference, there are people deliberately misled the court, you know, came before the court and said the statement I gave earlier was wrong, and I want to change my statement. So, and the question here should be, how should we address this then? Because I think the ICC, being a court that should look at those who are most responsible, you know, for the crimes against humanity and in other international crimes, should let this now be an issue to be dealt with by Kenya.
But must the ICC comply? Must the ICC comply and hand over these documents?
Oh yeah, oh yeah.
Well, you see, cooperation is in good faith, and the two parties, both Kenya and the ICC, must talk to each other about this. These are issues that they must reason together with and ask themselves, you know, what's the best way forward. It's not in anybody's interest to be confrontational about this, because you want closure on this. What at the end of the day, what would you want? You want the truth.
So, Wakili, that is why I'm saying I agree with your legal position, but what I'm saying is now we are going into a situation of musical chairs. What we really need to do now is to call Walter Baraza, as well as other people who are involved in this case, including those who gave false evidence, and we need to create a system, a body, where they can come and tell the nation what role they played, and we forgive them.
Is it
yes, you know, like
so you're trying to suggest we call Moses Kuria?
Yes,
and
everybody.
Well, they're in the same party.
Once they say that, in exchange, because you know, if we go this way, if they jail Baraza tomorrow, or bet, do you think justice will have been done? It depends on how you look at it. What we want is for these guys to acknowledge somebody made a mistake somewhere, and then we forgive them.
I think the primary of a crime was actually to mislead and to give false evidence, or even to procure false evidence. Even before we go to the interference of the witnesses, we must also look at the source of the evidence that was presented to ICC. We go backwards and say this and this evidence is what we based our...
the slaughter of many Kenyans, the torching of their homes, the loss of property, and that the fact is that unless that there's the feeling that that primary crime has actually been dealt with, then justice and reconciliation has not been served.
You know, where we lost it is where the investigation were shoddy. Otherwise, the justice of the victims could have been achieved if we were able to handle the investigation properly. But we cannot start saying that we can start with barazas and what. I think we can go a way of moving forward as a country, forgiving each other, reconciling, and taking care of the victims, and ensuring that anybody who was a victim has been adequately compensated.
Well, my view is that, and I agree with Prof and Honorable Waweru here, that for us we need to move forward and for especially justice of the victims, I think it's an issue that has to be dealt with. What is the justice of the victims? I mean, what is the interest of the victims, especially truth finding? And we need to look outside the box. Let's not just concentrate on prosecution as the only means of bringing out truth, especially for closure and for victims. Let's look at other mechanisms, alternative justice mechanisms. Look at Rwanda, how it had mechanisms to ensure that other than the International Criminal Tribunal for Rwanda, there were other mechanisms to reconcile societies, because as much as we can say that societies now are living together peacefully, without that kind of closure, without people coming to say, you know what, I admit that you know, I did this, I brought false witnesses against you, or I did ABCD, there is need to look beyond prosecution as a mechanism to ensure that we have closure in regard to the 2007 and 2008 post-election.
And how would we start that? How would you insulate such a process so that it doesn't appear to be, you know, taken lightly or just sort of talk shop?
The problem with highly formalized processes is that there are lots of stakes. But when you come to informal processes of truth-seeking, when you introduce amnesty to, you know, people who could have taken some roles in these events, then it becomes easier for people to open up than it would be for strict court processes that would require, you know, proof beyond a certain threshold for someone to be convicted, because then it leaves divided, it leaves parties at war. But if you make them more informal, more easy, more approachable, community-based from the grassroots, then I think it's a better chance to ensure that there's closure.
And you know, Anne, when we began the discussion, you raised the matter of Kenya withdrawing, and you wanted to pitch this case within the domain of the theory of withdrawal, and I think let us not be bitter about the process, even if some people think they have lost. They have not lost, because we still have a country to look after. But what is important is that even for our own president and the politicians like Honorable Waweru, the option is to reform I mean ICC, including even asking if a prosecutor doesn't do his job well, right, what punitive measures can we take against them, because that is not provided for in the Rome Statutes. And he is a lawyer, so that it's not just about somebody interfering with witnesses, but somebody earning a big salary at The Hague, but not doing the job. These are the reforms that Kenya should be suggesting. But the president and even the political class should never consider it an option to withdraw from the ICC.
I totally agree with the Prof. That we also need to look at, as much as we are talking about withdrawal, I think it's important for us to look at the institution of ICC. Yes. We see the kind of reforms that we can be able to advocate for, not necessarily to withdraw, but we can be looking at, we can be calling out there for reforms so that we can be able to get an ICC that can be able to serve us better. The other thing is we also need to, in those reforms, we need to look at the issue of evidence correction. They needed to have looked at this issue of Kenya professionally. They should have come here and not coming to the national park like Ocampo did. He should have come here and carried out a very thorough independent investigation as ICC, instead of depending on some briefcase NGOs who are just out there to make money. Again, I think even ICC should have taken more time before they prosecuted the case to ensure that they have been able to correct enough evidence and to talk to as many people as possible, because it was based more on hearsay and NGOs. But you as a politician,
your final views.
Yes, my views. You as a politician, Mheshimiwa, what should be preoccupying the government of Kenya right now is not even to set up an international crimes division in the High Court. What should be preoccupying you in leadership is to ask, what is it that caused people to kill each other in 2007? So that we don't even concentrate on the fact that the clashes occurred, but we concentrate in putting safeguards to
So that it doesn't happen again.
It doesn't happen again. And I am afraid, because you come from the ruling coalition, you are not doing much in terms of action. You are talking a lot, but you are not doing something much in terms of action to show that you want to avoid a future occurrence of what we experienced in 2007.
All right, final views, briefly, sir.
My views, especially on the ICC and the relationship with Kenya, I feel that ICC should have engaged better with Kenya, and you know, to ensure the whole idea of positive complementarity is to ensure that institutions are strengthened, not to be at the war path with each other. And I think there are several lessons to be picked, and if we are to engage further, and I think we can strengthen the ICC and how it works better from inside than from outside. So we need to engage better. We need to build that trust where the prosecutor of the ICC can share, you know, material with Kenya and so forth. So I think going forward there need to be better engagement.
All right, finally.
I think we have seen a lot of things done. A lot of reforms. You remember, if that time, 2007-2008, we didn't even have a new constitution. There were even talks in Serena. We had Agenda 1 up to 4. I think we have seen through 1, 2, 3, but we haven't exhausted the Agenda 4. We didn't have devolution, for example, then. We had, there were reforms in police, there were reforms in judiciary, and that is as far as internal measures were taken. But from the outside, I also feel like we need to look at institutions, international institutions like ICC, and see how best we can reform them, so that we can never have that kind of mess in investigation. But finally, I have seen, you have seen the commitment of our government. You have seen the president said we will never go back to that level again. You have seen the deputy president talking about we will never have Kenyans fight each other, kill each other because of political competition, and we have made an undertaking that we will never allow this country to go back that route.
All right, gentlemen, I thank you for your views this evening. We're taking a short break. We're back.